Get ahead of your 2024 goals with MyCase, rated the #1 legal practice management software by Capterra. Track time, create invoices, manage client intake and communication, and more, all in one place. Maximize every minute and start the new year right. DC Bar members receive a 10% discount on MyCase. Get started at mycase.com/DCBar.
Hi everyone, welcome to Brief Encounters. I am Joanna Tsai and I'm here with Teisha Johnson to discuss the new merger control guidelines. I'm an economist and co-head of the merger practice at Cornerstone Research, and Teisha is an antitrust partner at Baker McKenzie, where much of her practice centers on merger-related matters. Welcome, Teisha.
Thanks, Joanna. Very happy to be here.
Teisha, before we get into the meat of the discussion, can you provide a quick background on the merger guidelines, in particular for the non-antitrust audience?
Absolutely. On December 18th, just last month, the Antitrust Division of the Department of Justice and the FTC, the Federal Trade Commission, jointly issued their highly anticipated final version of the 2023 merger guidelines. Now, the merger guidelines, they set out an analytical framework for how both agencies, the DOJ and the FTC, assess whether a transaction, which can be a merger, an acquisition, it can be a licensing agreement, or any other combination, may violate the antitrust laws. Particularly, the guidelines help to assess whether a transaction presents a significant risk to competition to warrant intervention by the authorities. So if we back up just a little bit, actually more than just a little bit, we're going to back up decades. The first guidelines were issued in 1968. And in 1968, when the guidelines were issued, there was an emphasis on market structure and concentration. The guidelines were revised in 1982, 1984, 1992, 1997, and the last revision was in 2010. Unless you're speaking about the vertical guidelines, which were issued in 2020, but then they were recanted. So we're not going to talk about the vertical merger guidelines, specifically sticking with the horizontal merger guidelines. Those have not been revised since 2010. These new guidelines, issued in just last month, represent a bit of a shift back to the original policies back in the 1960s and earlier, where there was a focus on market structure. So there was a focus on the number of firms in a market and concentration trends. The guidelines from 2010 moved away from that focus and focused more on harm to consumers. You see that not stated as much in these guidelines. These guidelines really focus on the structural aspects of the market and the firms. So the new guidelines represent a little bit of a departure from the old guidelines back from 2010. And in the words of Lena Khan, the new guidelines aim to restore competition and strengthen democracy. And for those who don't know, Lena Khan is the chair of the FTC. That's a summary of the background. Do you have anything to add, Joanna? I know you're very familiar with these guidelines as well.
Yeah, I would expand more later, but for right now, I second your sentiment here that this was really very highly anticipated event in terms of the final guidelines being issued in the last month. Before the final guidelines were issued, the DOJ and the FTC did share a draft of the guidelines earlier last year, and they had sought comments from the public on their draft guidelines. What are some of the key takeaways from the final guidelines and some differences you see from the draft version?
So the final guidelines mirror very closely the draft guidelines, but not 100%. So I think we'll start with some of the key takeaways from the final guidelines. At a broad 5,000-foot overview, the guidelines reflect agency thinking and, again, a significant change in approach from the 2010 guidelines. There is a bit of a change in approach from the draft guidelines, but it's very minor. So the older guidelines, one thing that they did update in this newer version from the draft the draft had almost no references to any modern cases. There's been a string of losses from the agencies in court lately. Those cases were not referenced. In the new guidelines, they do reference some of the newer case law, which was not included in the old guidelines. And some of the sort of key takeaways, I think, from the new and final guidelines are the first thing is that they set a lower threshold for a presumption when a transaction will lessen competition. This presumption is set now to 30%. So the guidelines state that if the post-merger share, which means after the merger is consummated, the post-merger share is 30% or more, and there's only a small increase in concentration, this is presumed to violate the antitrust laws, even if one party only has a small percent of market share. Now, a presumption doesn't necessarily mean it's going to violate the antitrust laws, but there's just this presumption, which means that the agencies are going to look at the transaction more closely in all likelihood. This is a significant change from 2010 and a significant update because this 30% number was not in the 2010 guidelines. And there are a lot of antitrust practitioners and companies and others who think this number is incredibly low. You know, how the courts view this number, it's still to be seen because, of course, they were just issued last month. But I think that number is really one of the biggest takeaways from the final guidelines. I think another big takeaway, again, back to structure. So this 30% post-merger share is a structural presumption. Another sort of number in the final guidelines is a 50%. And that really relates to vertical mergers. So in the new guidelines, there's a signal that 50% market share by itself could be suggestive of monopoly power in the absence of countervailing evidence. Now, this is set out in a footnote, and it specifically relates to vertical mergers, but it can be read to suggest that the agencies will apply a more aggressive standard to finding monopoly power in a merger context to that 50% threshold, right? Even in the horizontal merger context. So I think that was another sort of key thing, even though it was in a footnote. That's one of the key takeaways from the guidelines.
Thank you, Teisha. And what will the agencies look for when determining whether a merger will harm competition per the latest guidelines?
So the new guidelines set out really 11 factors. And now mention all 11 so that you have heard them. The first one is that the mergers may raise a presumption of illegality when they significantly increase concentration in a highly concentrated market. The second is that a merger can violate the law when they eliminate substantial competition between firms. The third is a merger can violate the law when they increase the risk of coordination. So the 1 through 3, you're hearing about significant increases in concentration. This again goes to your structural sort of 30% plus share, substantially lessening competition. And when you increase the risk of coordination, of course, which can happen if a market is highly concentrated. Now, of course, it depends on how you define the market. But however you define the market, if the agencies find that it's highly concentrated, or if there have been previous, or actual attempts to coordinate, or if there's been elimination of a firm with a disruptive presence in the market, like a maverick, that can increase the risk of coordination. So that's 1 through 3. 4, a merger can violate the law when they eliminate a potential entrant in a concentrated market. 5, mergers can violate the law when they create a firm that may limit access to products or services that its rivals use to compete. Now, this one is interesting because in situations involving vertical mergers, where a transaction gives one firm control or access to a product or service or its customers that rivals use to compete, the agency will analyze the ability and the incentive to limit access to an input or customer necessary for a rival to compete. They will analyze whether the market structure, the merger's purpose, and if there's a trend towards vertical integration. They will also look at whether there's access to rivals' competitively sensitive information and whether there are any barriers to entry resulting from, threats or disruptions to rivals' access to an input or a customer. And as we spoke about above regarding vertical mergers, the agencies, one thing in the new guidelines, again, we talked about it's now a footnote that a party having, 50% share in a vertical merger can infer sort of monopoly power. So mergers can violate the law, again, when they create a firm that may limit access to products and services that its rivals use to compete. And what I just went through, those factors are what the agencies will look at to analyze whether or not a firm may limit access to a product or service. And number 6, mergers can violate the law when they entrench or extend a dominant position. Now, what is a dominant position? There's no number in the guidelines, but the guidelines do look to market shares, market power, such as whether or not a firm has the ability to raise a barrier to entry or whether they're eliminating a nascent competitive threat. Number 7 is when an industry undergoes a trend towards concentration, the agencies will consider whether it increases the risk that a merger will substantially lessen competition. Again, we're back to the substantially lessening competition. Number 8 is when a merger is part of a series of multiple acquisitions, the agency may examine the whole series. This is based on serial acquisitions. So the agencies are looking at whether a company is doing multiple acquisitions. They call it serially acquiring, kind of rolling up all of the smaller, either current competitors or potential competitors. And if there's serial acquisitions, the agencies are going to look at whether or not those acquisitions can lead to a dominant position, or if you already have a dominant position, whether it can expand a dominant position. The 9th guideline, when a merger involves a multi-sided platform, the agencies examine competition between the platforms, competition on a platform, to see whether it may violate the antitrust laws. Number 10, or sort of the 10th guideline, is when a merger involves competing buyers, the agencies examine whether it may substantially lessen competition for workers, creators, suppliers, or other providers. Now, this is a new one, new meaning not from the draft guidelines, but new from 2010. There's a focus here on labor markets. That was not at all mentioned in the 2010 guidelines or previous versions. So the agencies are going to examine, whether the merging firms have the power to cut or freeze wages, whether they can slow wage growth, whether they can increase their leverage in negotiating with workers, or whether they have the ability to degrade benefits and working conditions. So all of these things are going to be looked at as part of the merger, which is different from the 2010 guidelines and something that most antitrust practitioners haven't been focused on in the past 5 years. And I think most companies haven't been. So this is a new area for the agencies to focus on. And sort of the last guideline is when an acquisition involves a partial ownership or minority interest, they're going to examine its impact on competition. So this relates to the acquisition of a non-controlling stake in the company, so a minority acquisition. The agencies may look at whether that transaction gives the minority owner the ability to influence the competitive conduct of the firm, or to reduce its incentive to compete, or to gain access to non-public, competitively sensitive information. This is new. There hasn't really been a focus on minority acquisitions, but this puts everyone on notice that moving forward, the agencies are going to look at minority acquisitions just as closely as it looks at, the acquisitions of control. So these are the 11 guidelines that the agencies will look to when they are going to determine whether or not a merger will harm competition moving forward. Now, as a reminder, these guidelines are not law. The courts, not the agencies, are going to ultimately determine whether or not these guidelines, as they're being applied by the agencies, violate antitrust law. So it's still to be determined whether the courts will follow these guidelines and the agency's interpretation of how the guidelines should be applied in the merger control context. While the analytical approach from prior versions of the guidelines of the agency's merger guidelines have been cited favorably by federal courts, it remains to be seen how the new guidelines may be received in court. Part of the reason that I think that they've been cited favorably by courts is because there's been economic theory behind these decisions. So from the economic perspective, Joanna, what is new in the 2023 guidelines that parties and agencies need to be prepared for in evaluating merger transactions?
Actually, I see a ton of economics in the new guidelines, and there are definitely new elements, and we are seeing more guidance on the elements that have been around for at least more than a decade. And even for some of the new analyses, I will say that we have been implementing some of them in recent years, even before the latest guidelines. And they have now been made more explicit in the latest guidelines. So, to summarize the new elements, there are quite a few. One new element is from one of the guidelines that Teisha mentioned earlier. It's about serial acquisitions and whether, when a merger is part of a series of multiple acquisitions, the agencies will examine, in essence, the cumulative effect over multiple acquisitions and the impact of the cumulative acquisition strategy under other guidelines, such as, for example, whether the merger would entrench a firm's already dominant position to determine if the acquisition strategy may substantially lessen competition. So, in other words, this means the agencies will not only look at just the proposed merger at hand, but will analyze the effect of the series of acquisitions on the marketplace as a whole. Another new element in the guidelines relates to the analyses of a merger that involves multi-sided platforms and the evaluation of competition between platforms on the platform and to displace the platform. So this new part of the guidelines seeks to evaluate essentially the platform operator or participants' incentives and potential conflicts of interest. So I'm going to give an example here and what that means to an economist. So, for example, a platform operator's acquisition of a major seller could deprive rival platform of that seller and the buyer that gets attracted by that seller. The types of economic analyses to understand whether that's likely would include the existence and significance of other alternative sellers and the flexibility of the buyers on the platform to switch to other sellers. Alternatively, the acquisition may also affect the platform operator's incentive to, say, treat the seller it would own better than other sellers on the platform, thereby disadvantaging the other sellers. Here, we would want to understand what the platform operator would gain versus lose in doing that, in disadvantaging other sellers, which would also include an assessment of the existence and significance of any other platform alternatives that would be available for other sellers to turn to. As you noted earlier, Teisha, competitive effects for labor and input markets is also another new element under Guidelines 11, merger between competing buyers. For many mergers, the concern is over whether the merger would result in substantial lessening of competition such that the merged firm would compete less for customers and prices would be higher or quality would be lower for consumers. Assessing the competitive effects for labor and input markets is aimed at evaluating whether the merger between the two companies would reduce the competition between them as buyers for employees or for input and raw materials for their businesses. So in a sense, it's a more 360-degree view, so to speak, to assess the effect of the merger between the two companies on the different aspects in which they compete, whether it's for customers, employees, or suppliers. Another change in the latest guidelines is a lower threshold, as Teisha, you mentioned. So I'm not going to spend a lot of time here. I will just mention that, the 30% combined share with a small increase in concentration would yield a sort of presumptively anti-competitive result. This means that all else equal, more mergers will be deemed presumptively illegal, although that presumption can be rebutted by, for example, showing that the merging parties are highly differentiated and or do not face substantial competition from each other. So this leads then to one of my favorite topics, which is evidence of head-to-head competition or lack thereof, to show whether there is substantial competition between the parties that would be lost after the merger. This is particularly important for cases where shares can understate or overstate the competitive significance to one another. So in other words, large shares does not mean the two parties compete substantially with each other, and small shares does not mean they do not compete. For example, they may both compete for a segment of the customer where not many others compete for those customers. One type of economic analysis that we conduct to assess evidence of substantial competition between the parties is, for example, to analyze whether the parties have consistently gained sales at the expense of the other. Finally, the latest guidelines is very explicit about looking beyond just prices for evidence of competition between the parties. And the assessment will look for whether the merger would result in worsening of terms along any dimension of competition, such as quality, investment, choice, or product variety or features.
Thanks, Joanna. That sounds like a lot of different economic analyses to prepare for, both for the parties as well as the agencies. Given that parties have finite resources, what is your suggestion with respect to where the focus should be?
That's a great question. And it will, of course, depend on the case. And at the beginning of an evaluation, we need to be cognizant of the different theories of harm that the agencies will be exploring. While the guidelines does set out 11 guidelines, not all will necessarily be applicable to one case. So for example, as discussed, one of the guidelines is about platform competition. So that will not apply to mergers that do not involve multi-sided platforms. For both the parties and the agencies, I think it's a good use of time and resources to look to where there might most likely be competitive effects and focus on understanding those first. If you cannot get comfortable with those, then the merger is associated with particular risks. As part of the source of evidence for why a merger would be anti-competitive or pro-competitive, the new guidelines stresses econometric analysis and economic modeling, especially those using high-quality data and adhering to rigorous standards. So for complex mergers, empirical and rigorous economic analyses are particularly important, as they can be informative in distinguishing whether a particular merger is harmful or beneficial to competition. As my colleague Ari Gerstle, who recently joined Cornerstone from the DOJ's Antitrust Division, said, after nearly 2 decades in enforcement, he has learned the importance of remaining dispassionate in the search for economic truth. Sometimes his colleagues at the Antitrust Division entered a merger review absolutely convinced that the deal will harm competition or skeptical about potential theories of harm. But ultimately, the priors can be trumped by empirical facts that show diversion to goods outside the market really is substantial, or that the estimated harm isn't nearly as large as initial crude estimates may suggest. So Teisha, all in all, what do you think will be the impact of the guidelines?
Thanks, Joanna. I think, as we've both already discussed or started to discuss, that there will be an increased likelihood that more transactions will be subject to review by the agencies and will be subject to longer reviews and potential challenges in courts. The guidelines, again, have not yet been challenged because they're so new, but I do believe that they will be challenged in court this year. Whether those challenges will be successful will depend on the facts of the case. So it remains to be seen how these new revisions will be received by the courts and what the actual impact will be. But I think there's no doubt that the guidelines will ultimately go before the courts, and we will closely watch the outcome of these. Again, as I stated earlier, it's important to know that these guidelines are not law. So although the agencies rely on these guidelines in their review process, I think there will be, again, increased challenges because the agencies will use these new guidelines to challenge mergers that potentially would not have been challenged under the 2010 guidelines or the prior versions of the guidelines. For example, mergers that may have raised few competitive concerns under the prior guidelines. For example, if the only concern is labor market, that may be challenged under these new guidelines, whereas in the prior guidelines, a challenge based solely on labor markets we would not expect to see. So I think, moving forward, the impact of the guidelines is still to be determined. Ultimately, it's going to be up to the courts to determine whether the agencies have gone too far with the new merger guidelines or whether the courts think that the agencies have got it just right. The courts, not the agencies, are what determine law. So the courts will ultimately determine whether a deal violates antitrust law. So ultimately, I do think in the short term, we'll see more challenges. We'll see more questions from the agencies for transactions, and it may impact the number of transactions that are notified, particularly since we can expect to see, I know this isn't for this podcast, a future podcast, but once the revised HSR form is issued, we will see how the revised form and all the new questions correlate to the new guidelines. And these two big, huge changes combined may create a dampening effect on, mergers and acquisitions and combinations, that are subject to merger review. So it may dampen M&A activity over the long term simply because a lot of these guidelines haven't been challenged in court. So companies may be a little bit hesitant to move forward with acquisitions and transactions that may hit these new structural thresholds, again, that 30%. So still remains to be seen what the full impact of the guidelines are, but I do think there will be longer challenges, more challenges, and perhaps a slowdown in deal work. Joanna, I don't know if you agree with that. That's just my prediction. Please feel free to hop in and give your predictions as well.
Yeah, thank you. I think there are lots to look forward to in the upcoming year and the years to come, essentially, as we see how the guidelines are implemented and how they are viewed by the courts, as you said. I do think that, as we've mentioned, and as I outlined earlier with respect to the analyses that would be needed and required in order to examine each mergers, that could tend to mean that mergers could become much more expensive in the review process and could take longer. And uncertainty is always tough on businesses, right? And so I would be very interested to see what sort of effects that would have on merger volumes.
Completely agreed. Thank you so much, Joanna. I don't think we'll see a decrease in litigation. Litigators get ready and antitrust practitioners get ready, and economists.
Busy times ahead.
Absolutely.
Thank you, Teisha.
Thank you.
This episode of Brief Encounters was brought to you in part by our sponsor, MyCase. DC Bar members receive a 10% discount on MyCase. Get started at mycase.com/DCBar.